okay, there's a huge flaw here that I believe no one but me has noticed. Seller also notes that during the municipal court hearing, buyer confirmed that the computer was used solely for business purposes on the record. What you may not know is that in Pennsylvania, in a municipal court hearing, there is no record.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
We received a rather, should I say, smug email from one Amro Elansari. And I don't mean smug in an insulting way, but if you followed Amro Elansari, you know that there's a certain attitude to what he writes. And he is very happy that he claims to have beaten Best Buy and Dell. I just beat Best Buy and Dell on appeal. I fully expect and demand a name-clear video. I don't know what this is going to be yet, but we'll definitely cover the news that that Amro has won an appeal. But stay tuned. It's not quite what I think he thinks it is. By the way, love the show and what you do. People should have more access to the law, and shows like this help. That's the point. That's exactly why we're doing it. The reason my legal writing is a shortcut or not formal is because even with formal writing, these corrupt judges just find as they want, so might as well skip the formalities and just go for it by getting to the point, which explains some of the summary and shortcomings of my legal writing in the past, but it is in no way indicative of my legal skill. I write as a pro se litigant on purpose because average people should be able to succeed on these claims, even if they are not lawyers. Okay. I think that's a bit of a cop-out, but okay, sure. That's his response to why he writes in the style that he does. Well, without further ado, what is it exactly that he has won? Now, a couple things real quick. This is a non-precedential decision, which usually means exactly that. It's not precedential, so you can't use this case as an example of how other cases should be handled. So there's still some stuff in here. The 3-judge panel of the Superior Court of Pennsylvania, which is Pennsylvania's middle appeals court, admonishes the judge for not doing the proper job with Amro Elansari's Best Buy complaint. And this is why you see some judges taking some of the strategies that they do and dismissing Amro Elansari's cases only after evaluating certain steps of the law. For example, the pro se informa pauperis filings that he makes. They'll grant the informa pauperis. They'll explain that they're going to now dismiss the case, and they're going to explain the law under which they're going to dismiss the case, and all of that. Why they do that is because if they do something less, it really opens them up to be appealed, and then the judge has to fix it later anyway. So better eat crow while it's young and tender than when it's old and tough, right? Well, this judge didn't do that, apparently. And well, not the judge here. So this is Judge Kunzelman that's writing here. The lower court judge didn't do enough of a job to prevent a successful appeal by Amro Elansari. And it starts. Pennsylvania's unfair trade practices and consumer protection law give consumer the rights to sue anyone who tricks them into buying or leasing goods or services with one big caveat. A consumer must use the good or service for mainly personal, family, or household purposes. Thus, the statute does not cover business-to-business transactions. And remember, we're talking about Best Buy here, so what the judge is saying already is that if Best Buy sells you something for personal, family, or household purposes, that falls under Pennsylvania's unfair trade practice and consumer protection law. If it is Best Buy, a business, selling it to another business, say when they sell to Lawful Masses for Lawful Masses' recording purposes, then Pennsylvania's unfair trade practices and consumer protection law does not apply. So that's important here. The plaintiff buyer class representative Amro Elansari appeals pro se from the order sustaining the preliminary objections of the seller Best Buy and manufacturer Dell of a apparently Dell computer purchased at Best Buy. He alleges they deceptively marketed that computer and violated the law. Buyer's amended complaint indicates he used the computer for a personal purpose, but the trial court, in sustaining the preliminary objections, exceeded its scope of review by relying upon facts outside Buyer's amended complaint and overlooked the law and its legal precedents of this court. We therefore modify the order and remand for further proceedings. So this means that they're not declaring Amro Elansari the winner. It means he's won his appeal, and then it goes back to the court, who dismissed it at the very beginning of the litigation stages. So now we're basically going to go back to where we were the beginning, and now he can play the rest of the litigation game at the common pleas court level. Facts. According to the amended complaint, in February of 2018, Buyer was in the market for a new, powerful desktop computer and found a deal for such a computer for $380 in-store only at Best Buy. And remember, these are facts as alleged. These are not facts that have been proven. The appeals court is not finding these facts to be true. The appeals court has to take these facts as true as part of the standard of review. Buyer intended to use the new computer for streaming on Twitch.tv, a purpose he alleges was a personal purpose that did not rise to the level of a commercial use. Buyer compared his purpose to Skyping regularly with people at a very consumer level or consumer-like use. So this is actually a really cool distinction that's going to be made here in this case. And it's not precedential, so I can't use it. But the judge is going to have to evaluate whether purchasing a computer for use on Twitch.tv, for use as a streaming, outgoing streaming computer, does that automatically make it a commercial purpose? Twitch pays people money to do this, or at the very least, there's the prospect of eventually being paid money to do it. So isn't that a commercial purpose? Or maybe people have the right to have hobbies that arguably cross the line into commerciality, but just don't do so with a primary purpose of commerciality. Let's keep going. Purchasing an identical computer directly from manufacturer would have cost at least $500, so Buyer went to seller's brick and mortar store to take advantage of the in-store only price. Thus, he claims the seller lured him into its store with an advertisement for manufacturer's computer on sale for $380. Once Buyer entered the store, seller's employee said the advertised $380 computer was unavailable. The employee offered Buyer another one of the manufacturer's computers for $500 instead. Buyer purchased the higher-priced computer from seller. Buyer began using manufacturer's computer, found it unfit for regular use. It would freeze and overheat regularly. The computer froze and overheated over 30 times in the month of April 2018. Again, reminder, these are the facts as they are alleged, not as proven, and the court is not finding these things to be true. The court is taking these things to be true. Buyer was stuck with a defective computer because neither seller nor manufacturer would replace the computer or refund Buyer's purchase price, even though it came with a 1-year warranty. Amro will have to prove all of these allegations now at the common pleas court level. So the court here doesn't get the option to say, well, we don't believe Amro. We don't think he's a credible litigant. This isn't the stage for that. The stage for that would be during and after a deposition, or when he's on the stand someplace. Since this is such a small amount of money, it might be put before an arbitration panel, and like this, the county's binding arbitration system. And that's where he'll end up having his credibility tested. The veracity of his facts or allegations will all be revealed there. For now, if he said it in the amended complaint, the judges had to take it as true during the initial stages with a motion to dismiss and all that. And that's why we're here. Buyer decided to file a small claims action. Maybe that's why we haven't seen it yet. He then discovered that seller was still advertising the same $380 computer 5 months later. Buyer saved the July advertisement and went to seller's store with a third party. That person entered the store and asked about the $380 computer. Again, an employee said the computer was not available and attempted to sell third party a more expensive computer. Realizing that he was not the only potential victim of this deceptive sales tactic, buyer sought recourse on behalf of all similarly situated consumers. In his amended complaint, buyer averred that seller not only knew, but has been intentionally running deceptive advertisements to trick consumers into coming to its store to purchase items at a higher price, which is a very well-established tort known as bait and switch. And that's true. And if these allegations are true, then yes, that is a kind of thing called bait and switch. Do we have time? Can I tell my own bait and switch story? I have a bait and switch story. This something that literally happened to me. I'm not even sure that they realized they were doing a bait and switch. I went to my local IKEA. I went to IKEA to purchase new kitchen cabinets. I was going to do my whole, I gutted my kitchen, and I'm putting in a whole new sink and dishwasher and under sink cabinetry and above counter cabinetry, and nothing like super high end. It's IKEA, but it was one of my first major housing renovation projects. This is my house. This is my housing renovation project that you can see here. My old house that I bought, and I'm slowly fixing it up. It's taking a lot longer than I anticipated. It turns out you need time and effort and money to fix up a house, and if you lack any one of them, then it makes it a very long and difficult and arduous process. So yeah, lesson learned. But anyway, so I went to IKEA, which is an hour away for me, down in Norristown, Pennsylvania. And I went to IKEA and I selected these beautiful kitchen cabinets, and they were on sale for 40% off because they were trying to clear out old stock. They were making room for new stock. They were making there was no hidden anything. They told us up front, it's old stock. It's like we're moving on to the new model. So Len's gonna buy the old model. And they were really cool too. They were like dark, like mahogany, and they had like a wavy glass with like a wire in it. Just like looked cool, like a wavy glass with like wires, like a grid of wires going through it. Looked really cool. And so you would then light the cabinets, and that would show through the window and the glass and the door and everything. So I placed my order, something like, I don't know, $800 or $1,000 for the cabinets at the 40% off price or whatever. And the sink and all that. It was everything. It was actually not $1,000 was not bad for that. And when the day came that they were supposed to have arrived, drove down there with a truck to pick up everything, and they said, "We're very sorry. We accidentally sold all of the inventory. We don't have any more inventory. Here, we'll give you your money back." Well, wait a second. What does that mean? Follow it out with me. I've now lost my 40% discount. I'll get my money back, and I still have a gutted kitchen that needs cabinets. So I still need cabinets. I've planned on cabinets now. I've depended on my delivery date. No one had called me ahead of time and said, "Yeah, we screwed up and we're going to have to refund your purchase." And even then, that might not have been good enough if they already took my money. So what it means is I was going to go have to purchase cabinets at regular price, and I was going to have to purchase one of the new models. No discount. Well, I said the words bait and switch. And I was like, I'm not leaving until I get whatever something that looks like the cabinets that we selected, something that is acceptable to me, and it's at the 40% off price. So I did end up getting it. I just had to sit there and make a big stink about it for about 5 minutes, and then somebody went and talked to the manager, who talked to another manager, and they decided to let it go. And so for no additional charge, I got my kitchen cabinets, just in a different style. And yeah, that's a bait and switch. And I don't even think they meant it that way. I think they just accidentally pulled a bait and switch that time. But it's a common tactic. Advertise a loss leader to get people into your store, a loss leader being a product that you sell more or less at a loss in order to get people in your store. And then you're hoping that they're going to buy stuff. And you don't want to get customers like Leonard French, who are really, really good at going and getting the loss leader and then leaving the store without buying anything else. Although I guess I'm also really bad about that in other respects. Like when I go grocery shopping, I can't walk into the grocery store for less than a full load of groceries. I can't go to Costco without spending at least $100. It's like, there's certain stores you just don't go to unless you're okay with spending extra money, or you're going to be really disciplined about not buying extra. So Amro Elansari may have needed this computer, and so when he went to buy the $380 computer, but all that was available was a $500 computer, he may very well have fallen a victim of a bait and switch. And so he'll get a chance to prove that now. So he, buyer, alleged that seller knowingly and willfully misrepresented to buyer and the class, because remember this is a class action application, that seller's rates would be lower than standard market conditions on various occasions, particularly in-store only as well, when in fact its rates are not what are advertised and in fact may be higher or non-existent at all. This deception caused buyer and the class to pay substantially higher rates than those otherwise available in the market, and also to acquire products that were inferior in quality. I'm not sure how that means they got a product that was inferior in quality. I guess the $500 product was inferior in quality. How does he know? Maybe the $380 computer had all the same problems. Buyer seeks damages and an injunction against seller from continuing to misrepresent its rates to Pennsylvania consumers. It seeks legal fees and costs. As mentioned, buyer initiated this lawsuit in Philadelphia Municipal Court. There we go. So I should have read that far, and I wouldn't have spent $17.50 in Center County Court. That court ruled in favor of the defendants, and buyer sought a trial de novo, brand new, in the Court of Common Pleas. Defendants filed preliminary objections to the original complaint, which the trial judge sustained. So in Pennsylvania, let me compare here Pennsylvania to federal law. In federal law, when we talk about a motion to dismiss under Rule 12b, 1, 2, 3, 4, 5, 6, 7, usually 12b6 is failure to state a claim upon which a court can grant a remedy. You have to state a claim and have a remedy. Otherwise, you can suffer a sustained motion to dismiss under Federal Rule of Civil Procedure 12b6. Well, we're in Pennsylvania here. We don't have the federal rules of civil procedure. We have the Pennsylvania rules of civil procedure and criminal procedure and the Pennsylvania Code and all that. So here we have what's called preliminary objections, which would be our version of that motion to dismiss. You're objecting on the grounds that something's deficient with the complaint. And that's why Amro's complaint is going to get dismissed, because something was deficient with it, allegedly. So buyer filed an amended complaint, which is the answer to a preliminary objection. So if you get a document called preliminary objections, if you get a series of objections, you can address those objections by either answering the preliminary objections directly, saying, I agree with this one, I don't agree with that one, whatever. Usually you would answer by saying, I disagree with them all, because if you agreed with any of them, then you might go fix the problem and file an amended complaint. And then the amended complaint nullifies the preliminary objections to the non-amended, to the original complaint, and then the preliminary objections have to be refiled as to the new problems or the uncorrected problems in the amended complaint. So it just starts a whole new round of those things. So he made an amended complaint listing 4 counts, breach of contract, the unfair trade practices and consumer protection law, breach of implied covenants or contract, and unjust enrichment, and instituting a class action. The defendants renewed their preliminary objections in the nature of a demurrer on all 4 counts, an objection to an opponent's point that is irrelevant or invalid while granting the factual basis of the point. So a demurrer would be like, yeah, we agree in fact, but we disagree that that's relevant in law. Because the case had become a class action, the parties agreed to transfer it from the trial court's arbitration division to its commerce program. Thereafter, a commerce judge issued an order sustaining the second set of preliminary objections as to both defendants Best Buy and Dell, and dismissed the amended complaint with prejudice. With prejudice is usually reserved for the adjudicated kind of disposition, where a judge has been able to decide that the complaint has no merit, that a judge or jury has been able to make findings on the merits. So this is basically acting as a finding that this claim has been adjudicated. The trial court ruled that buyer purchased the computer for a business purpose. exempting the transaction from the unfair trade practices consumer protection law. The court also determined that buyer and defendants never entered a contract and that buyer did not plead sufficient facts to demonstrate unjust enrichment. Buyer timely appealed. So buyer raises one issue. He asks whether Twitch screaming? He asks whether Twitch streaming, the act of broadcasting oneself over the internet, a trend that is common and popular among many today as a hobby, a business, and a sport, constitutes a business per se or automatically to prohibit a person purchasing a single computer for Twitch streaming from asserting protection under the consumer protection and bait and switch laws. In its response brief, manufacturer argues that we should affirm the order dismissing it with prejudice on alternative grounds. We address both issues in turn. Buyer's purpose for the computer. Buyer asks whether the trial court erred by deeming his live streaming on Twitch a business purpose as a matter of law. Buyer contends buying a computer for that activity is no more a business purchase than a person purchasing some paint for an art project or cleats for soccer. Just as the purchasers of those goods might become professional artists or soccer players, buyer accepts that a Twitch streamer may one day become a professional internet sensation. However, buyer says it is absurd to hold that his purpose for the computer was a per se business purpose, just as it would be absurd to hold that amateur artists and youth soccer players buy their supplies and equipment for business purposes. To highlight the error of the trial court's decision, buyer directs us to the IRS regulations. He claims that the IRS draws the line between a business and a hobby at a threshold of $10,000 of income. Because buyer's purpose produces income below that line, he suggests that it was error for the trial court to conclude that he engaged in a business as a matter of law. In short, absent a continuous stream of $10,000 in revenue, there are absolutely no grounds to consider buyer's purchase a business purchase, even if buyer, a non-lawyer, believed this to be a business. In other words, buyer argues that this is an objective test, not a subjective one. Hence, his initial subjective view of the purpose is irrelevant. In response, seller quotes a few random unconnected allegations from buyer's amended complaint. It then adopts the trial court's analysis that buyer made a purchase for business purposes that fell outside the protections of the unfair trade practices and consumer protection law. To support that contention, seller cites to buyer's original complaint. Seller also notes that during the municipal court hearing, buyer confirmed on the record that the computer was used solely for business purposes. Okay, there's a huge flaw here that I believe no one but me has noticed. Maybe someone else has noticed it. Say it while you got a chance. But seller also notes that during the municipal court hearing, buyer confirmed that the computer was used solely for business purposes on the record. What you may not know is that in Pennsylvania, in a municipal court hearing, there is no record. You have to bring your own record. You have to bring your own stenographer if you want there to be a record of the proceeding. So I don't know if Best Buy is just not giving it their all because it's Amro Elansari and it's $380 and they don't care, but or what? But it just this is amateur hour on both sides, and Amro Elansari is winning on this one so far. So this is I'm kind of rooting for him too a little bit here.
This is amateur hour, and Amro has an excuse. What's Best Buy excuse?
Yeah, exactly. Well, Best Buy. Let me back off of Best Buy just a little bit. They're put in this weird position where they have to oppose his appeal. They can't just be like, yeah, we're okay with your appeal. Please continue to come after us. They have to oppose his appeal. But what grounds does Best Buy have? Best Buy wasn't really the reason why the thing got dismissed. Best Buy may have made the preliminary objections, but it was the judge that decided that this has to be a business purpose. So now maybe it's true that the reason it was decided that it was a business purpose is because he said that it was used solely for business purposes, but that was at the municipal court hearing. So let's see what happened at the common pleas court hearing. Because wouldn't manufacturer / seller slash defendant, wouldn't they make the argument that at the common pleas court hearing, he said the same thing where it would be on the record? And if he said it on the record, then it would be available for Best Buy and Dell to show to the appeals court judge. So I think Amro either got wise to that or something, and that part is not on the record, or Best Buy was unable to find that on the record. Now it will become part of the record. If this goes forward in court, there will be depositions or discovery or interrogatories or something, some questions under oath that will definitely get answered. But now he knows better. He knows not to answer the question that it's a business. And anyway, is it really a business? I mean, come on, like let's be fair here. He's not a famous streamer yet. Let's let him have the same rights and privileges that everybody else does. It wouldn't really be considered a business at this level anyway. Manufacturer similarly relies on the trial court's reasoning that buyer purchased the computer for business purposes. It also argues buyer levied no factual allegations that would render manufacturer liable for damages under law if proven at trial. It cites the amended complaint's allegation that manufacturer did not take affirmative steps to prevent seller's allegedly unlawful conduct. Manufacturer therefore asks us to affirm the order dismissing it from the case, even if it's on alternative grounds. So Dell's saying we didn't have anything to do with this bait and switch campaign. When an appellate court rules on preliminary objections in the nature of a demur, whether they were properly sustained, the standard of review is de novo and the scope of review is plenary. So de novo standard of review means they're going to review everything brand new. The scope of review is plenary meaning wide or broad. So it's not a narrow scope of review where they're reviewing one specific thing and they're limited to that by law. No, they can review the whole thing. We may affirm an order sustaining preliminary objections only when, based on the facts pleaded, it is clear and free from doubt that the complainant will be unable to prove facts legally sufficient to establish a right to relief. In other words, we must resolve any doubt in favor of reversal. Like I said, it's like the motion to dismiss standard in Federal Rule Civil Procedure 12b-6. You must take the facts in a light most favorable to the non-moving party. In this case, Amro is the non-moving party in the motion to dismiss. So you must assume his facts are true. All inferences that can be taken in his favor have to be taken in his favor, just for the purposes of surviving a motion to dismiss. If the thing can survive a motion to dismiss, that means that there is something to be resolved in trial or discovery. And then once we resolve those things, then they can make us a second motion to dismiss, but we don't call it that. We call it a motion for summary judgment in federal law. For the purposes of evaluating the legal sufficiency of the challenge pleading, the court must accept as true all well-pled, material, and relevant facts alleged in the complaint and every inference that is fairly deducible from those facts. When, as here, there is an amended complaint of record, we take these facts from the amended complaint. Thus, our scope of review only includes the amended complaint. Here, the trial court ignored buyer's amended complaint. Instead, it cited the original complaint and a transcript from the municipal court hearing, which defendants attached to their preliminary objections. The trial court opined as follows. Buyer did not purchase the computer for reasons covered under the UTP-CPL. Rather, buyer stated in the municipal court hearing that he bought the computer for a business and commercial purpose. In the original complaint, buyer explicitly averred that he purchased the computer for a very specific business legal project. In the amended complaint, buyer contradicts his previous testimony and pleadings by alleging the computer was intended for purposes personal in nature. It appears to this court that buyer is reforming his former testimony in the hopes to properly plead this cause of action. However, buyer does not have standing to sue under UTP-CPL because he bought the computer for a business and commercial purpose. As such, buyer's unfair trade practice and consumer protection law claim against both defendants is dismissed with prejudice. Now, I get it if he said that it was for a commercial purpose in the original complaint, and then later says in his amended complaint, no, it's not. That seems like he's doing a little bit of a bait and switch himself, huh? I mean, as soon as he figured out that he can get dismissed for it being that, he just pled a different fact. But the complaint is not where the facts have been evaluated yet. So if he changes the pleading, that doesn't mean the judge can find that he admitted. Sure, it's an admittance in the complaint, but he amended it out. They didn't make, would it have been better for them to go forward on that complaint and then they could have used that as evidence against him, whereas now they can't use it as evidence against him? Certainly, the fact will be borne out in discovery. The Unfair Trade Practices and Consumer Protection Law, as its name implies, is a legislative enactment to protect the public from fraud and unfair or deceptive business practices. This court described the UTP-CPL as legislative enhancements of pre-existing common law protections that include the codification of a list of practices designed or designated as unfair or deceptive and therefore unlawful. The law enhancements also included previously unknown methods for victims of unfair trade practices to seek judicial relief. One such method is a private action to recover actual damages or $100, whichever is greater. That statute authorizes a trial court in its discretion to award up to 3 times the actual damages sustained, but not less than $100, and to provide such additional relief as it deems necessary or proper. The court may also award costs or reasonable attorney's fees. That private cause of action only extends to persons who purchase or lease a good or service primarily for personal, family, or household purposes. This primary purpose clause ties a plaintiff's right to bring a private action to the purpose for which the good or service is used. Pennsylvania's leading case on the primary purpose clause is Valley Forge. There, a condominium association hired a contractor to install a roofing membrane that Maimco International manufactured. After the contractor installed the good, Maimco issued a 10-year warranty directly to the condominium association. 2 years later, the roof leaked. The association asked the contractor and Maimco to honor the 10-year warranty. The contractor made one repair attempt. It failed. After that, the contractor and Maimco refused to return the condominium association's phone calls, so the association sued both companies for breach of express warranty, breach of the implied warranty of merchantability, breach of the implied warranty of fitness for a particular purpose, and a UTP-CPL claim. Maimco filed a preliminary objection in the nature of a demurrer to the UTP-CPL count. The preliminary objection asserted that the condominium association had never contracted for a warranty, and the condominium association was using the good for a business purpose. The trial court agreed and dismissed the UTP-CPL count with prejudice. We reversed on appeal. First, this court rejected the notion that the association could not sue without a contract. That's fine. Second, the trial court reasoned because the association's business was maintaining the condominium building it had purchased the good for a business purpose. We branded this logic fundamental error. Maimco argued on appeal that the roofing membrane was a commercial product. We declined to adopt such a rigid interpretation. Instead, this court held that the various purposes of the unit owners controlled the question of why the condominium association, as their legal representative, purchased the good in the first place. To ascertain those varied purposes, we examined the facts alleged in the operable complaint and opined as follows. The condominium building upon which the roof was placed here was primarily used for personal, family, or household residential use by the unit owners or their lessees. While the record reveals that some of the units in the building were used for business purposes, neither the number of such units nor the square footage involved would provide a basis to conclude, at this nascent stage in the proceedings, that business rather than residential use predominated. We note in this regard that because a leak-proof roof is ultimately essential to the structural integrity of the whole condominium building, it is the primary preponderant purpose use of the whole building and not the most directly affected units, which would control. Hence, we conclude that giving the condominium association the benefit of all facts pled and all favorable inferences reasonably derivable therefrom, the roof was purchased primarily for personal, family, or household purposes within the meaning of those words in the UTP-CPL. We refused to hold that the condominium association's primary purpose, its preponderant use, for the good was business, even though the association purchased the good in conjunction with its business operations. The alleged facts indicated that the unit owners had mixed uses for the good, and our exacting standard of review for orders that sustained preliminary objections required us to resolve all discrepancies of fact in favor of the plaintiff, the condominium association. In other words, where the alleged facts were unclear, it was error of law to deem the association's purpose for the good a business purpose automatically or per se. In the matter at bar, the trial court repeated the fundamental error that our appellate courts rejected in Valley Forge. The trial court interpreted the facts of record in the manner that was least favorable to the plaintiff buyer. In fact, it compounded that error by basing its entire decision to dismiss on facts not properly before it and credited those facts over the allegations of the amended complaint. Now, the defendants ask this court to perpetuate that error by also exceeding our scope of review and considering facts outside the amended complaint. This we may not do. Whatever buyer testified to in the municipal court and whatever was in the original complaint are irrelevant at this juncture of the case because they are beyond our scope of review. Remember, law students, your standard of review, scope of review. So even though the scope of review is plenary, they still can't take into account things outside the amended complaint, including the original complaint. Moreover, even if we could review those pre-amended complaint facts, they would still not sustain the order before us. The purported class has alleged a conflicting purpose for buyer's purchase, and buyer has abandoned his prior allegations and legal theories. He has a right to do so at the pleading stage. And that's important. That's worth highlighting here. He has an absolute right to abandon his prior legal theory at the pleading stage on preliminary objections. A party, either by filed consent of the adverse party or by leave of court, may at any time change the form of action or otherwise amend the pleading. That's Pennsylvania Rule of Civil Procedure 1033. The rules shall be liberally construed to secure the just, speedy, and inexpensive determination of every action or proceeding to which they are applicable. Our liberal construction extends to the right to amend the pleadings within the statute of limitations, to revise the allegations and legal theories, and to state an actionable claim. Amendments to a complaint which change the cause of action, if made before the statute of limitations has run, are freely authorized by the rules of civil procedure when the defendant is not prejudiced by such an amendment. The original complaint omitted the UTP-CPL and pled facts that precluded the statute's coverage. After reading the first set of preliminary objections, buyer apparently reconsidered his legal theories, amended the complaint's allegations, and thereby changed the cause of action within the statute of limitations. Because this suit's underlying events occurred in February of 2018, and buyer filed the amended complaint that same year, it is clear that he filed the UTP-CPL count of the amended complaint within the 6-year statute of limitations. Therefore, the defendants have suffered no prejudice by the amendment, and the trial court should have accepted the allegations of the amended complaint as true to decide the preliminary objections. Having explained the trial court's procedural misstep, we now turn to the operable pleading, the amended complaint. That pleading alleges buyer used the computer for a single purpose, personal in nature, that did not rise to the level of commercial use. To support that contention, buyer relies upon hypothetical analogies and the regulations of the IRS distinguishing between businesses and hobbies. We begin with the regulations. In administering the Internal Revenue Code of the United States, the IRS must regularly classify taxpayers' activities as businesses or hobbies because the tax consequences for each differ. To guide those determinations, the agency promulgated regulations indicating, much like Valley Forge above, that the question is fact-sensitive. with case-specific nuances that may not lend themselves to a one-size-fits-all pronouncement. Instead, the IRS has implemented a 9-factor test in which no one factor alone is decisive. See IRS publication, How Do You Distinguish Between a Business and a Hobby, available at this link. Nothing in the IRS regulations sets a financial line of demarcation at $10,000 to render an activity a business, as Beyer suggests. Thus, Beyer does not persuade us to establish $10,000 of income as the threshold between a personal use and a business use under the primary purpose test. Still, we do find the regulations helpful. So is this like the shotgun theory? Like Amro, said 10,000 and like he fired at the target. He wasn't aiming properly, but he still hit the target. So, okay, we're going to give it to him. Still, we find the regulations helpful. They reflect the wisdom of the agency's experience in wrestling with cases like this one. A person's preponderate use for a purchase governs under the primary purpose clause. Where the facts are in dispute, a plaintiff must prove that his main use for the good or service was personal, familiar, or household in nature by a preponderance of the evidence. Beyer argues the use will vary from person to person based upon the needs and goals of individual purchasers. We agree. A person who buys paints for her daughter's first grade arts and crafts is quite different from, say, Michelangelo buying paints for the Sistine Chapel. Between those black and white extremes, the paints quickly blend into shades of gray. Say the school student went to a store and bought the paints herself. Was her purpose personal or educational, and is that a distinction without a difference? Would it matter if the public school teacher bought the paints? In that scenario, do we examine the teacher's educational use, or should we consider the student's personal use given that she was the end user? Does the result change if a student is in college earning a Master of Fine Arts instead of elementary school? If she sells a painting for a profit at a summer arts festival, do the paints she used to create it during the previous school year suddenly become a business purchase? The hypotheticals are endless. The same conundrum exists for Twitch streaming. At what point does the non-business purpose of streaming live over the internet to interact with friends cross the threshold into a business venture? While casual streaming from one's home with friends is certainly not commercial, a person streaming full-time and earning thousands of dollars annually is obviously in business. Between those two polar opposites, though, this court has no idea where the line of demarcation falls, and we are unequipped to make a definitive pronouncement on the paltry record before us. What we can say is that the amended complaint alleges Beyer's Twitch streaming was a personal use. In fact, unlike Valley Forge, where the complaint alleged mixed uses by the various condominium unit owners, the amended complaint at bar avers that Beyer's use was only personal. Thus, it was error for the trial court to make a contrary finding of fact at this stage of the proceedings and hold as a matter of law that Beyer used the computer for business purposes. And then here's the dismissal of the manufacturer. Our review cannot end here. Manufacturer asks us to affirm its dismissal on alternate grounds. Indeed, this court is not bound by the rationale of the trial court and may affirm on any basis. If Beyer has not alleged sufficient facts in the amended complaint to sustain a UTPCPL cause of action against manufacturer, remember this is Dell and no longer Best Buy in this paragraph, we may still affirm the trial court's order. Manufacturer orders the amended complaint has established no basis from which Beyer may recover against it. Manufacturer notes Beyer is a remote purchaser of its computer purchased at seller's store located in King of Prussia. It further asserts the amended complaint is devoid of any actual allegations of improper conduct on manufacturer's behalf, nor does it cite to any specific statute, law, or regulation that manufacturer is alleged to have violated. Appellate courts in this Commonwealth have long chastised trial courts for dismissing a complaint with prejudice without granting plaintiffs leave to amend the deficient pleading. Indeed, if it is possible that the pleading can be cured by an amendment, a court must give the pleader an opportunity to file an amended complaint. This is not a matter of discretion with the court, but rather a positive duty. Thus, only when it is clear and free from doubt that a plaintiff has no path by which to amend a complaint to conform to law may we affirm the dismissal of a defendant with prejudice on preliminary objections in the nature of a demurrer. To determine if the facts in buyer's amended complaint might give rise to a UTP-CPL claim against manufacturer, we examine the statute. It dictates unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce as defined by subclauses, etc., are hereby declared unlawful. Unfair methods of competition and unfair deceptive acts or practices means including failing to comply with the terms of any written guarantee or warranty given to the buyer at, prior to, or after a contract for the purchase of goods or services is made. Thus, the General Assembly has barred persons from failing to honor any written guarantee or warranty. To prove such a violation, strict technical privity was not intended by our legislator. Privity would be basically the parties to a contractual obligation, or in this case, a warranty obligation. So is a manufacturer so far disconnected from the warranty that they should be able to get out of it? No. They're the manufacturer. They made the good or service that's under warranty. Thus, the Valley Forge Court held that the warranty Maimco delivered to the condominium association after the contractor installed the roofing membrane was enforceable under the law, even though the association never directly contracted with Maimco. In subclause 14, the legislature curtailed the offering of warranties to the public, most of whom are not attorneys, during retail sale, only to later disclaim those promises under the niceties of contract law. Indeed, it appears manufacturer is attempting that escape route from this lawsuit by reminding us that buyer is a remote purchaser of its computer purchased at seller's store. However, if manufacturer offered buyer a written warranty, it may not shirk its promise to repair, replace, or refund the purchase price so easily. Buyer alleged that the defective computer had a warranty for 1 year. However, he did not specify which defendant gave him that warranty or whether it was in writing. Even so, it is a reasonable inference to draw from the facts alleged that at least one, if not both, of the defendants gave that 1-year warranty to buyer. Because buyer has not fully developed this potential violation in his amended complaint and failed to attach a written warranty as an exhibit, buyer has not pled sufficient facts in his amended complaint that either manufacturer or seller violated the law. However, buyer's claim of a 1-year warranty impliedly indicates one or both defendants. Therefore, it is too early to dismiss manufacturer from this lawsuit with prejudice. Buyer may file a second amended complaint to flesh out his UTP-CPL theory under the law against manufacturer if he can produce a written warranty from manufacturer. Accordingly, we decline manufacturer's invitation to affirm the order of dismissal with prejudice on alternate grounds. The trial court erred by granting judgment as a matter of law to the defendants because the amended complaint does not allege that buyer used the computer for business purposes. On the contrary, it undoubtedly alleges he used the good for personal purposes. Also, our de novo review of the amended complaint and the law reveals buyer alleged facts hinting at a possible basis for recovery against manufacturer for an unfulfilled warranty under section 20114. A second amended complaint may be appropriate. Accordingly, we modify the appealed from order as follows. And it does say here that the appeals court may modify any order brought before it on appeal. So they're going to modify it, not just dismiss it or remand it or whatever. And now this 9th day of January 2019, which was the lower court's order, upon consideration of the preliminary objections of defendants Best Buy and Dell, it is hereby ordered that the preliminary objections of both defendants are sustained as to counts 2, 3, and 4, which I'm guessing is other counts, not the UC, not the unfair competition law, unfair trade practices law. It is further ordered that preliminary objections of Dell are sustained as to count 1 of the amended complaint, so that means that he'll be given a chance to do a second amended complaint, and that leave is granted to Mr. Elansari to file a second amended complaint against Dell. It is further ordered that the preliminary objections of Best Buy are overruled as to the unfair trade practices consumer protection law. Order affirmed as modified, case remanded for proceedings consistent with this memorandum, jurisdiction relinquished from the appeals court back to the common pleas court. So Amro Elansari pretty much hands down won his appeal, at least on count 1. And as long as he can produce that warranty, which I don't see any problem with him doing that, I don't know where I would go find my manufacturer's warranty from long ago, but he could at least allege it, that they do provide a written warranty and he just can't find it. I don't know. That's not legal advice though, Amro. Don't take that from me. Anyway, so yeah, he won his appeal and now he gets another chance to prove that he shouldn't have been denied the $380 computer. You might remember where this came from, and I hope we don't get ourselves demonetized from this, but this was the Superior Court document. And so I guess actually this is the Superior Court. This is the appeal. So this is how he talks to the judges. So Best Buy indicated there was a 1-year manufacturer's warranty, etc. And then when he gets down here to the facts, a $380 in-store ad February, scammed plaintiff, $500 buy, computer is broken, same ad being run this whole time, there was never any computer, there was never any computer, there was never any $380 computer, they're scammers, they're criminals trying to deceive people out of money, etc. This is not about Best Buy and Dell, it's about the Pennsylvania court system and how hard it makes it for an average individual to access, etc. And he just, he continues to go off. He goes into his eviction and his cannabis card and how he was arrested for selling cannabis, even though that's not what he's allowed to do with that cannabis card. He calls everybody frauds. He's let everybody down. You are living embodiments of disrespect to the American flag, and your lack of integrity is to your own name to bear, etc. The amount sued for is $29 billion or $119 billion. So remember, this is in this case. So the judges are giving him the real benefit of the doubt, which I don't know if you remember from what we saw here. He really thinks that they are going to continue to give him the benefit of the doubt. I write as a pro se litigant on purpose because the average people should be able to succeed on these claims, even if they are not lawyers. Which I don't know. I think he can still do a better job, even if his purpose is to write as a pro se litigant. I don't know. My gut feeling is that that's a cop out. That he can't write better than that. But good for you, Amro, that you were able to win on appeal, and I hope that you're able to get your $120 back plus whatever they say you're due. I wouldn't expect a windfall, but that's not legal advice. That's just me talking. Go get your own attorney if you want legal advice. I'm not going to be your attorney, not me. Thank you for joining me this morning. I am Leonard French, your favorite copyright attorney. Thank you for supporting us on patreon.com/ljfrench and sponsus.com/law. Your support is what makes this channel possible. We have taken Brandon full-time as a contractor in the month of October and continuing for the indefinite future here. And we could really use your support to make sure that we can pay him a appropriate living wage and sustain ourselves as well. I would still like to go see Kaylee and Luxembourg and pay for all the expenses for the business and all that. So we really need your financial help. Thank you very much for that. Thank you to our October channel sponsor. Thank you to Joshua Davis from TandaPay. And thank you to our $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. Wow, there are a lot of you. Really love to see that. Thank you so much for all your support. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will be on the crawl in front of me on the videos that drop. You're all in the description. See more in the description. We have merch. We have links to TandaPay articles and all of your names as well. So go see yourself there. Love you all. Thanks for joining. Don't forget to share. Don't forget to subscribe and click the bell. Don't forget to like the video, and I'll see you later. I'll leave you with some dog video here. Love you all. Bye.
Hi. What are you doing in the window? In the window. You have a nice view. As much as I would love to have you in the window. Off. Off. Good girl.